All right, thank you all for being here. We're gonna give a brief presentation talking about some of the history of the outstanding Florida Springs harm rule, and then Rachel is going to talk to us about the lawsuit that we filed a couple weeks ago. I am Ryan Smart, Executive of the Florida Springs Council. I'm happy to be joined by Rachel Curran, who is staff attorney with the Jacobs Public Interest Law Clinic for Democracy and the Environment. I think I got that right. And we also have James Adams here on the Zoom, who is a Stetson Law student who helped us with this brief as part of the clinic work. So happy to have James here. The presentation should only take about 15 minutes, hopefully, if we do it well. If you have questions about a particular slide or something we're saying in the moment, feel free to interrupt and ask your questions then. If you have general questions, we should have ample time to do those at the end. So to start off, this all comes from Senate Bill 552, which was signed into law by Governor Scott in 2016. Senate Bill 552 was a large bill, but one provision in it was called the Florida Springs and Aquifer Protection Act. One of the things that act found was that action to protect outstanding Florida springs was urgently needed. One facet of that bill was amending Florida's water use permitting laws to include a new subparagraph, 373.2193, which specifically designed to protect 30 newly designated outstanding Florida springs. 373.2193 basically has two requirements, and they are requirements because the law says shall, not may. So this is something that the legislature was telling the Department of Environmental Protection they had to do. One of them was to adopt uniform rules for issuing permits, which prevent groundwater withdrawals that are harmful to the water resources. In this particular case, those water resources being outstanding Florida springs. And two, in order to implement that rule, adopt a uniform definition of the term harmful to the water resources. So now we're 8 years, more than 8 years past the passage of that law. It was passed in January of 2016, went into effect in July of 2016. From 2016 to 2021, FDEP took no action. So they never published a draft rule, never held a workshop, never made any attempt to actually adopt and implement these rules that were required. While that was happening, the water management districts continued to issue water use permits, causing harm to outstanding Florida springs. And as a result, we have several of those outstanding Florida springs, and their spring runs are currently violating their minimum flows and levels. In other words, they're suffering significant harm from overpumping when the law says that no permit can be issued, which even causes harm. Some examples of spring systems suffering significant harm include the Wekiva Rock system and the Santa Fe Chatuckney system. We have other systems that have not been evaluated in a long time, but where we're certainly seeing the impacts of overpumping, like Weeki Wachee, Silver, Rainbow. Another part of that same 2016 law was a requirement that FDEP create rules to implement the Central Florida Water Initiative. The Central Florida Water Initiative was a legislative directive to create more water for development, as opposed to the Springs Harm Rule, which is designed to reduce the use of water to protect springs. By 2021, DEP had completed that process. So they had drafted a 60-page rule that includes an applicant handbook in order to create the Central Florida Water Initiative rules. And you see that with a lot of things, where when the department is tasked with doing something that seems to have a benefit to the development community, it gets done expeditiously. Another example would be the failed attempt to turn 404 permitting over to the state from the feds. We went through the rules, in this century, looking at how long it's regularly taken DEP to follow a legislative mandate. And on average, most rules are proposed and adopted within 4 years of the legislative mandate. Of all the mandated rules where FDEP has published notice of rule development, only the Springs Harm Rule has been left unproposed and unadopted for as long as 8 years. So finally, in 2022, after the Florida Springs Council had sent several letters to DEP Secretaries Valenstein and Hamilton, threatening litigation if they did not propose a rule, DEP finally published their first draft rule to implement the statute. Unfortunately, that first attempt at the rule was basically the exact same permitting rules that had been in place since 2014. It has been around a while. You might remember CUPCON, the Consumptive Use Permit Consistency that the legislature pushed. So these were the rules that were adopted as part of CUPCON and all the districts in 2014, 2 years before the legislature mandated that they adopt new rules to protect springs. In 23 and 24, FDEP again published similar draft rules. Again, the permitting rules were those same rules that were in place from 2014, while the definition of harm was lifted from the Central Florida Water Initiative, which again was not an initiative to protect our environment, but an initiative to find water to allow development to continue in Central Florida. So is this what they were supposed to do? Should they have been proposing essentially the same rules that were in place? Well, the sponsor and principal author of Senate Bill 552, who specifically wrote 373.2193, had a discussion about that during one of the legislative committee meetings. And he said it is something that is a major step forward in the protection, preservation, and cleanup of our springs. What we are doing is we are putting together a new standard here, not something that has been previously done, but a new standard that defines what is going to control the issuance of permits. And it says we shall prevent groundwater withdrawals, which are harmful. I don't know how much better the legislature can do in putting something together than this. In my time in Tallahassee, Senator Simmons has been the person who understood water issues and water law the best, and I think has done the most to try to protect them. So he clearly is saying right here that what he was telling the department to do was to create new standards that will prevent harm to outstanding Florida springs, making no action unacceptable, but also making their proposals to implement the same rules that were already in place invalid. So now I'm going to turn it over to Rachel to discuss the legal action we filed earlier this month.
Thank you, Ryan, for that introduction and for that history. First, I want to just explain what a law clinic is for those of you who don't know. I'm with the Jacobs Public Interest Law Clinic out of Stetson Law, basically a law firm that's attached to a university, allowing students to gain real-world experience here. And we're particularly interested in cases that are at the intersection of failing democracy and environmental harm, and this would be exactly that. And we've filed, so what we filed is a complaint for a writ of mandamus. A writ of mandamus is an ancient, extraordinary writ at common law, actually. So you're not going to find this in any of the statutes. And it's something that we turn to as a last resort. We filed that in Hernando County, which is the home of Weeki Wachee Springs. A lot going on there and elsewhere. And also happens to be right next door to us down here. But there are 6 of those ancient types of writs. Go ahead and go to the next slide. And this mandamus writ means we command. So it's when a court is ordering an agency to do something that it should have already done, and it needs to meet 4 elements in order to be entitled to that sort of relief. And again, that is extraordinary relief, something that we're not doing unless we have literally no other option. And that is that we have a clear and certain legal right. We do feel that Florida Springs Council meets that threshold. In fact, any taxpayer in the state of Florida, any citizen, has a right to see the laws that have been passed by their legislators implemented. And that right is to the performance of a specific non-discretionary duty. Again, the Senate Bill 552 didn't leave DEP any discretion, didn't give them any sort of wiggle room to say, hey, you shall adopt these rules. And there's no way that the DEP can get out of doing that. There's no discretion there. They failed to perform that duty despite an adequate request. Florida Springs Council sent several letters, and you'll see those in the complaint, attached to the complaint, and has attended the sort of farcical workshops that haven't led to anywhere as well. seeking these rulemakings. And again, we have no other method of retaining legal relief here. Draft rules aren't challengeable in DOA. They're not subject to a Chapter 120 action. Only proposed rules are, and after 8 years, we still don't even have a proposed rule. We only have these draft rules, which left in draft form are meaningless and unchallengeable. So that leaves us here with this complaint that we've filed. Go ahead and go to the next slide. And we find this to be a dereliction of duty, not something that's acceptable, and it's not negotiable as well. Go ahead and go to the next slide. So what are the next steps looking like? So we've already gotten what's called an alternative writ. We got that issued yesterday by Judge Vergara in Hernando County. That means that she's read our complaint and finds it to be facially sufficient. She doesn't see anything wrong with our request. We've met all of those elements already. And it's now up to DEP to explain themselves, explain why they've given us the runaround for 8 years. Once DEP is served, which should be any minute now, they'll have 20 days to respond, and then we'll have 20 days after that for a reply brief. And then it's up to the court to go ahead and issue that writ of mandamus. And we've asked for that to be issued immediately because, again, we're not messing around anymore. So once that judge issues that writ, and we're hoping we get that writ soon, FDEP will be forced to propose a rule for adoption. And it's only once we get that proposed rule that rule could be challenged under a Chapter 120 typical DOA action that you're used to seeing for rulemaking. And with that, guys have any questions? Happy to answer them.
I have a question. This is Greg Allen with NPR.
Hi, Greg.
Yeah, so right now there's a draft rule that's out there. Couldn't they just say this is going to be final, and then you'd have to and fulfill the writ that way?
Correct, they could. And one would wonder why they haven't done that for 8 years. You can only suspect that it would be to avoid this very litigation that we're now forcing them into. So again, a draft rule isn't challengeable, but a proposed rule would have been. And so that's keeping us in this holding pattern, which is what's made this complaint for a writ of mandamus necessary.
Right. Okay. So that would seem to be I mean, and so they could do that, and then the writ of mandamus would be satisfied. Then you have to go to the next step, then presumably.
Correct.
That happens. Do you think that's
exactly?
Likely to happen? What do you think, Ryan? Is that likely to happen?
I think that I don't know if they're going to fight us through the process until they, the judge issues a writ, or if they're, going to proactively propose the rule. In either case, we win. Our goal here is just to get a proposed rule, because until that happens, we had to use an extraordinary legal motion like this or writ just to get them to do the minimum of proposing a rule, whether it's good, bad, and different. So we need the rule out there so that we can have something to challenge if it is insufficient.
If I could ask another question, then maybe you could talk. It goes back to what, 2016 when this was first passed. Between then and now, what kind of negative impacts have we seen on some of these key springs like Wekiva and Weeki Wachee? I mean, have things gotten worse since 2016? And if you could talk specifics, right?
Right. I mean, they certainly have, and even though that 2016 law also required new updated minimum flows and levels for our outstanding Florida springs, they're still in the process of adopting those. Looks like the first one that's going to go will be the Santa Fe. And I know that they're also at work on Wekiva. So for the Santa Fe and Wekiva, those spring and river systems remain suffering significant harm. So they are still below their adopted and soon to be revised minimum flows and levels. But you can also look at this from a water quality perspective. When we talk about water quality in springs and nitrogen pollution, we talk about it as a concentration, right? The total maximum daily load is a concentration. It's milligrams of nitrogen over liters of flow. So if you want to restore a spring system's water quality, you have two ways to do it. One way is to reduce the amount of pollution entering the groundwater. The other way is to increase the flow to the spring vent. And when you look at the astronomical reductions that FDEP, themselves acknowledge they have to achieve in the spring systems, there's really no way to do it simply by reducing pollution. Part of the answer is going to have to be increasing flow. So, we don't have the capacity to go out and measure spring flow independently ourselves, but we do have the water quality data. And we also know that in the time that since this law was passed and these rules should have been adopted, hundreds of consumptive use permits, which harm the springs, have been issued, right? I mean, if you think about just common sense, if a spring system is suffering significant harm from overpumping, you can't possibly issue a consumptive use permit that doesn't cause harm, because you already have harm. You're beyond that. You're causing significant harm, and you're making that significant harm worse.
Hi, Ryan and Rachel. Thanks for that. Rose here from WUFT. My question is, so this is the second time, if I have my numbers right, that the FSC is suing the FDEP. What do you hope goes differently?
Well, last time we won. So, it'd be nice to win quicker, I guess. The last legal challenge lasted for many years. We ended up going all the way to the First District Court of Appeals, where they invalidated the Basin Management Action Plans for not meeting the minimum requirements of this same law. And yeah, the first lawsuit against FDEP was the Basin Management Action Plans. That was a much more complex lawsuit, not just looking at a very simple question here: have you adopted a rule, right? But getting into the substance of the rule and, dealing with some of the finer points of statute. I mean, at the end of the day, it wasn't that fine a point. The law clearly said DEP had to have allocations, and they had no allocations. So now in these new BMAPs, we are seeing that FDEP does have allocations. So, my hope is we'll get the same result, just much quicker.
Yeah, and as far as timing, it's a good sign that we did already get that alternative writ from the Hernando County judge. Already finding that our complaint was facially sufficient and already ordering DEP to show cause. Again, this is the type of action where if we were to wait several years for a resolution, that in effect is a loss. It's besides the point. The point is to get things moving at the entirety of the relief that we're seeking.
And Max has asked, outside of any legal back and forth or letter writing, have you heard from anyone within DEP on these particular rules? Have they offered any reasoning for the delay? We've had multiple conversations with FDEP at the secretary level, at the deputy secretary level, and at staff level. FSC got together a group of attorneys, scientists, engineers, policy experts 4 years ago now to draft our own rule that we offered to DEP as a starting point for discussion on how to draft a rule that complied with the law. We've met with them multiple times to present that and discuss it. They haven't really offered any reasoning for the delay. It's been years and years of we're going to get to it without them actually doing it.
Can I ask, this is Greg again. Could I ask if Ryan, what's your thought about why they've delayed so long? Do you have any kind of opinion why, or suspicion of why it's taken so long to have this? 8 years has never been done before, right? Why this is so unusual?
Yeah, I mean, if you read the language, this is a very simple piece of statute, and it says very clearly that the districts have to stop issuing consumptive use permits that harm springs. I don't think FDEP wants to protect the springs, wants to tell the districts to deny these consumptive use permits. We can kind of see the direction that FDEP wants to go by looking at the draft MFL recovery plan for the Santa Fe River. That plan essentially says we're going to keep handing out permits indefinitely. And, we'll hope that on the back end, 20 years from now, we can find a way to make up the damage that's occurring. That rule basically takes away a mechanism that would, under normal statute, these permits should be being denied for causing harm. It was a recognition that the rules weren't working that led the legislature to say we need better rules, we need more protective rules for outstanding Florida springs. If again, FDEP has successfully and unsuccessfully proposed numerous rules over the last 8 years that are much, much more complicated than this. The difference is those rules benefited developers and the regulated community, while these rules would benefit our environment.
I'm suspecting that if you pass this, if this rule was adopted, at least the version that you wrote, it would be seen as hamstringing all kinds of development, business and residential, not to mention probably agricultural. There's all kinds of uses that it would restrict, and they could say it could bring growth to a screeching halt. Is that possible?
I think there's so much we can do on water conservation. You know, half of our domestic supply goes on our lawns, which is an incredibly wasteful use of water in a state that is now, you know, looking at the possibility of water shortages. You know, not that people's taps are going to go dry, it's going to be a while, but we're going to see, you know, we have seen folks having to dig deeper wells. We have seen lots of areas of the state. I mean, the Central Florida Water Initiative itself was you know, that was done because Central Florida has run out of easily accessible, cheap, fresh groundwater to feed development. So on one hand, you know, I think that what it would stimulate is it would stimulate much more conservation by our utilities, by agriculture. And I think it would move water to the highest value sources, right? You know, we're still at a point now where we're giving out permits for 1 million gallons a day to water bottling companies and spring systems that are already suffering significant harm, right? You know, benefiting the community maybe a little for a few individuals, but doing a lot of harm. You know, those profits are not staying in the area. But, you know, we have a permitting system for a reason. The idea was never that everybody gets as much water as they want. I mean, if that was the goal, why would the legislature ever have established a permitting system? You know, the other side of this is it's the law. You know, I didn't make this up. This was a bill that went through 3 years of committee hearings. The bill was supported by Associated Industries of Florida. It was supported by the Farm Bureau. It was supported by DEP. You know, if there were concerns about it, the great time to raise those concerns would have been during the 3-year legislative process, not to just decide, well, we don't like the law, so we're not going to do it until somebody sues us.
Hi, quick question. This is Molly with Central Florida Public Media. I apologize, I jumped in a few minutes late, so I apologize if you guys went over this, but I just wanted to clarify. Part of the rule requirement, right, or part of this requirement of FDEP is that they packaged in there is they needed to adopt a uniform definition of what harmful to the water resources means. Is that correct? And is like, if you could maybe speak on like maybe why that's important and why, like, but that hasn't been done, right? They haven't define that?
Hey, Molly, right. So they haven't done either part. You know, yeah, we talked about briefly at the beginning. There's 2 requirements here. One is to adopt permitting rules to prevent harm, and 2 is to adopt a definition of harmful to the water resources. You know, if you think about it, in order for the permitting rules to work, you need to have a definition so that folks, you know what is harm. Right? But the definition in and of itself isn't going to get us there, right? The definition is just kind of a necessary part of the rules. And it's really, I think, the rules that are going to determine whether or not we see our springs restored.
Right. And I also just wanted to ask, I just kind of wanted to point that out because, you know, not having something to reference, you know, to begin with what harm is. And so I also wanted to ask something that you guys put out earlier this year. Basically, the FDEP is passing responsibility for springs protection back to the water management districts, which is in direct conflict with the legislature's finding that coordinated statewide action is necessary. I guess I wanted to ask, you know, why is coordinated statewide action necessary? I guess what is the problem with potentially giving that back to the water management districts?
Well, I mean, the law says that districts can implement their own rules as long as they're more protective. You know, what the legislature was trying to do here was to set a minimum standard, right? You at a minimum have to provide this level of protection. If the districts want to do better than that, they're able to, but we need minimum standards. You know, the thing about the springs are, while it comes to pollution sources, they're very different. You know, they act pretty similar in that, you know, you can easily design a rule that would protect one outstanding Florida spring and protect all outstanding Florida springs when it comes to harmful water withdrawals. You know, it might change how much you need to cut back the existing permitting, but we don't have to have independent rules. And we have, you know, some permits now, as we better understand our water systems, you know, we have these basins that cross district boundaries. Right, so if you look at like the Santa Fe is affected by water withdrawals in both the Santa Fe River Water Management District area and the St. Johns River Water Management District area. When it comes to Rainbow Silver, they're doing one basin management action plan because it's so hard to tell where one basin ends and the other begins. Yet the permitting is one agency has response for Silver Springs, while the other is responsible for Rainbow. So, you know, at the very minimum, we have to have these standards that every district has to follow. And then if we see that that's not getting there and a district wants to go farther and needs to go further, they can.
Understood. Thank you.
Mhm. Well, Brenda is going to put a PDF of that presentation into the chat if anyone wants that to have that accessible for anything that's in there. And you all should have Rachel and Mai's contact info from the press release if you have get writing this tonight and have any more questions you want to ask us. We want to thank everybody a lot for being here and showing interest in this, and we will keep you informed on how it goes.
Bye, thank you.